Good morning. How's everyone doing today? Hope everyone is doing well. Welcome back. Welcome back. This is another episode of TLG Live. I am John Nia, one of the founding partners at Trowbridge Law Group. Today, I am going to be talking about, penalties, restitution, remedies, basically consequences. What happens if you screw up in your offering? What happens if you blow your offering? What happens if you commit some fraud or violate securities laws? Basically, there's a lot of different results that can happen, right? So let's start with the, lesser penalties, not serious, little things, right? If you make a little mistake, what happens, right? So example is we have to file the Form D when we do a Reg D offering. We have to file the Form D and state notices within 15 days of funds being irretrievably committed. So, for our purposes, for our clients, when you break impounds, when you use investor funds, within 15 days, we need to file the Form D for you. What happens if you don't tell us that you broke impounds until after 15 days and we file, the Form D late? Usually what happens is there'll probably be some sort of late fee. You're not going to lose your entire exemption. You're not going to blow your entire offering. You'll be fine for the most part. You just probably have to pay some sort of late fee. So that's the first penalty that can occur, right? Fines and fees, late fees, maybe, a little bit of a fine depending on the circumstances, if it's, egregious, right? So that's the first category, fees, late fees. The second category is a little bit more serious, right? Once you get into the area of you violated the rules of the exemption you're under, what happens then, right? So an example, and honestly, what happens most of the time in our space, private placements under Regulation D, if you blow your offering, if you lose your ability to rely on the exemption under Regulation D, oftentimes what happens is you're forced to make a rescission offering. Rescission basically is refunding all of your investors, rescinding the offering. So if you blow your offering, if you, so for example, if you're doing a Regulation D Rule 506B offering and you're not allowed to solicit, and you were found to have solicited investors, that's one of the things that you might be forced to do is a rescission offering. You will be forced to refund all your investors. Now, obviously, that can be easier or more difficult depending on how far you've gone along, right? If it's immediately after you started raising money and it's found out that you've solicited investors and you are forced to do a rescission offering, that could be relatively easy. Just refund your investors. You haven't used investor funds yet. If it's like a year later, though, and you've already kind of broken pounds and used investor funds, you might have to dig into your own pockets to refund your investors, which costs you, a bunch of money. Plus, the administrative cost of doing that, right? Going through that process of refunding all your investors. Plus, it looks bad, investors are going to see that, you had to refund them because you screwed up in the offering. And, the next time that you do an offering, investors might not be so willing to invest in your deal because of that. So, try to avoid that. That's why listen to your attorney, follow the rules, and you won't have to run into that situation. So what's next? What happens if you go a little bit further than that, and there's maybe a little bit of fraud, a little bit of misrepresentation in play? The next kind of remedy that's available to the SEC is disgorgement of ill-gotten gains, which is basically, the concept is if you've committed fraud and you've made profits from investor funds fraudulently, you shouldn't be entitled to those profits. So the SEC has the ability to seize those profits from you, right? That's disgorgement. But there's been a little bit of change recently. So that was the SEC's tool for, for however many years, right? They've been able to penalize fraudulent issuers and not only seize all their profits, but also, um, use it as like a punitive tool to penalize, and go after fraudulent issuers even further. It's kind of been reined in recently. Last year, there was a big Supreme Court case called Liu versus the SEC. We don't really get many big Supreme Court cases in the securities world, so it was big for us. But it was all about disgorgement, right? It was all about the fact that um, legislative or congressional, so Congress, gives the SEC its power, right, through the laws, and the power of disgorgement, the way it was written in the law was, it was not supposed to be a punitive tool. It's not supposed to be a penalty. So the SEC kind of reined that in and said, there's a limit to the amount that the SEC can seek as far as disgorgement. So it's kind of limited the SEC since last year. So going forward now, in enforcement actions, they aren't really able to go after as much as they were previously, which is interesting. A little bit of oversight from the SEC, from the Supreme Court, I guess. Anyway, that's disgorgement. So, obviously, if you're defrauding your investors and using your investor funds to make serious profits, that's the penalty you might face. So don't defraud your investors. Moving on to the most serious category, though, is jail time, right? So a lot of people forget or don't realize that you can go to jail for violating securities laws, or not necessarily violating securities laws, but you know, that's sometimes a consequence of violating securities laws is the fact that you can't go to jail. I mean, look at our old buddy Bernie Madoff, rest in peace. He ran a Ponzi scheme and he went to jail, and unfortunately passed away recently. But I'm sure some of his investors were cheering that. But that is a consequence or a potential consequence of committing fraud and violating securities laws. So it's not the SEC itself that's going to throw you in jail, but oftentimes they'll get the FBI and the DOJ involved to I guess investigate other crimes that are committed that can lead to jail sentences. So oftentimes when someone's running a Ponzi scheme, they're also committing embezzlement, money laundering, crossing state lines while doing that. Oftentimes there's postal fraud involved, because if you're mailing and receiving checks through the mail, and it's there's fraud with that, that's postal fraud. You could go to jail for that. So but it's very rare. I mean, we don't see it too often, but it is possible, right? So that's something to keep in mind. If you are thinking about raising money, obviously don't commit fraud. But if you are going to commit fraud, don't commit fraud to the level where you could go to jail. Is basically what I'm trying to say. But no, don't do any of that stuff. Hire a securities attorney, make sure that you do everything correctly, legally, in compliance with the law, so that you don't go to jail, you don't have to pay disgorgement, you don't have to do a rescission offering, and then obviously you don't want to have to pay filing fees, late fees, stuff like that. So yeah, easiest way, just hire a securities attorney, a good securities attorney to do everything for you and advise you on what to do. Anyways, that's what I wanted to talk about today. I hope you guys learned a little bit about what not to do. Today is Thursday. As always, there is another TLG Talks. I think today Gene is actually interviewing Austin Hartley, who I interviewed previously in my one TLG Talks I did. I guess I did such a bad job that Gene had to redo it for me. Anyways, I think you guys should go check that out. It'll be interesting. I hope it's interesting. I know it'll be interesting, and I'm going to check it out later. So that's today at noon Pacific time on our YouTube channel. Follow us here, Facebook. We got Instagram too. Go to our website, trowbridgelawgroup.com. You can schedule a free 30-minute consultation with me or Gene there. Thank you for tuning in, and I'll see you guys next week.